Hello, everyone. Good morning or good afternoon. Thanks for attending our webinar today. It's the beginning of the 2022 Business Litigation Webinar Series. This webinar is 10 ways to avoid cyber and privacy lawsuits. Before we begin, we wanted to cover a few housekeeping items. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of the screen. We'll try and answer them during the webcast if possible. But if we need to give a fuller answer, or we need more time, or we're running short on time, we'll answer it later by email. A copy of today's slide deck is available in the resource widget. We encourage you to download any resources or links that you may find helpful. You can find additional answers to some common technical questions located in the help widget at the bottom of the screen. The webinar today is CLE accredited in California, Illinois, and Texas for 1.0 hours of general credit. In Missouri, approved for 1.2 hours of general credit, and in New York, transitional and non-transitional for 1.0 hours of areas of professional practice. We award CLE based on attendance for the entire 60 minutes. Due to changes in jurisdictional requirements, you will notice that we are no longer using automated pop-up attendance checks. As required, we'll display secret words in 2 multiple choice polls during the webinar. You'll be required to select today's secret word from a multiple choice list. Please respond to these 2 polls to demonstrate your continued engagement and earn full CLE credit. We value your opinions and appreciate your participation in today's webinar. Thanks very much. So, as I said, today we're going to talk about 10 things to understand that can help you avoid getting sued for privacy and cybersecurity. And we're going to do that through, I'm giving you the introduction right now, but then we're going to work through 10 specific items that we think can help you avoid or at least mitigate lawsuits in this area. We'll give some closing thoughts, and then we'll take any questions that we weren't able to take during the webinar at the end. Let me introduce our panel. I'm Jim Shreve, and I chair the cybersecurity practice here at Thompson Coburn. I'm based here in Chicago and in the DC office. I've been doing privacy and cyber security work for 20 years. I'm the non-litigator on this panel, so I'm the one in charge with trying to help you avoid litigation in the first place. But if something goes wrong, my 2 colleagues gladly can come in and help save me and help you through litigation. So with that, I'll hand it off to my co-panelist, Luke.
Thank you, Jim. Hi, everybody. My name is Luke Sosnicki. I am a partner in Thompson Coburn's Los Angeles office. I am a financial services litigator. Primarily, I've been doing financial services litigation for the better part of 15 years. Representing all sorts of financial institutions and mostly consumer-driven lawsuits. I also have a very active privacy practice, advising institutions, including financial institutions, on litigation and regulatory risk, again, primarily from a consumer perspective, relating to data privacy and security practices. So thank you again. Drew?
Hi, everyone. My name is Drew Taylor Moore. I'm in the business litigation group, as Jim mentioned earlier. So I specialize in commercial litigation on the defense side, which covers a variety of claims and topics. But I've also gained a lot of experience dealing with a biometric statute here in Illinois called BIPA for short. So I've also dipped my toes into the privacy side of things. But I am also normally available to help not only with contract disputes, in addition to compliance work related to BIPA, but also other matters as well. So with that, Jim.
Thanks very much. So as I said, we're going to give you 10 things to understand how you can maybe avoid getting sued in privacy and cybersecurity. I would note that lawsuits involving privacy or cybersecurity have, on the whole, been less common and less costly than you might think over the last 20, 25 years. Certainly when a lot of the laws were enacted originally, There was a lot of people thought there'd be significant litigation under them, but there's been less than you would think. I'd say as we move forward, that outlook is changing. Here in Illinois, where Drew and I are this morning, it's a hotbed of lawsuits relating to the collection of biometric information. And the law that Drew referenced, BIPA, basically sat dormant for 10 years, but now has become the most important avenue for privacy claims in the entire United States. California, where Luke is based, has begun to become the epicenter for consumer actions relating to security breaches. Interestingly, this has happened due to a provision in the landmark California privacy law, CCPA. We hope to provide you with some tools that you can use here and some things to think about that may lessen your chance of getting sued, or at least mitigate some of the potential damages if you are sued. It's not a guarantee. I wish we could provide that. But unfortunately, even if you do everything right, you can still be sued. But we think these 10 things can help. So with that, let's get into the 10 items. First one is to understand your business. So understand who you are, what you do, and who you deal with. And to do that, you kind of need to take a bigger view than you might think. I mean, most federal requirements in the privacy and security space in the U.S. are industry specific. You have the GLBA requirements, and FCRA requirements in financial services. You have HIPAA requirements in healthcare, and you have various requirements that apply to if you're a government contractor. But these requirements can get you in ways you may not have necessarily thought of. And I think some of you out there, if you're in higher education, you know exactly what I'm talking about. If you accept federal financial aid, you're considered a financial institution subject to the GLBA requirements, which isn't apparent on its face. Receiving payment for medical services can make you subject to HIPAA. But maybe even more importantly is that contracts can push many of these requirements far beyond those regulated entities. So think about who you're dealing with. So consider your litigation risks as well as your regulatory risks as part of the planning process. New projects that you do could make your entity subject to new requirements and the source of liability. I would also note that privacy and security diligence has become a huge topic in M&A. So in mergers and transactions, we're seeing a whole lot more diligence in that space. So if you may merge with somebody or be acquired, expect that other entity is going to look into the potential privacy and cyber litigation liability that they may take on from acquiring your business. Or if you're acquiring somebody else, to cover those risks, you got to do that due diligence and see how much liability you may be taking on, because that is definitely increasing over what we saw, even 3 or 4 years ago. It is much bigger. So with that, we're going to have our first polling question here, and so we're going to talk a little bit about the types of information you collect here in just a moment. And so, first question is your organization currently using biometric information, such as for physical security, for online authentication, for your marketing purposes? And the answer choices are no, we don't do it at all. Yes, we do it, but only in customer relationships. Or yes, we do it, but only for employees, like say use biometric time clocks. Or yes, we do it in both our consumer relationships and in our employee relationships, both. So if you could vote on these, give you a few moments to cast your vote, and then we'll take a look at what the results are. Okay, so give me a moment there. Let's take a quick look and see what it said. No is the winner, which is surprising. I think in some ways that's good, because that avoids liability, but I'd say that's a response you should be sure about. I think, unfortunately, business lines often aren't consulting with the legal and compliance people. So, I think it's worth digging down into that to make sure that really is the case. Fewer in consumer relationships, a few more for employees, and some are using them for both, which I think is an increasing trend on the whole. So with that, I'll pass it on to my colleague, Drew.
Hi again. So really what we're talking about this first point, to whom the data relates, we're really talking about state laws for the most part, and defining what the subjects are and how they actually approach people who could bring claims, people who now have a statutorily created privacy right, individuals in that particular trench. And it sounds general because it is. What normally happens with these privacy laws is that you look at the language and it turns out that even if the title indicates that it's only relating to one class of individuals, there's probably a provision in there that either expands it or makes it applicable to different types of relationships. So when I'm going through these privacy laws, I actually try to divide them into the individual classes in 3 different categories. And these are non-exclusive. They often blend and cross over into each other. So just bear with me now. So the first category would be individual residents. Second category would be individual employees. And the third category would be individual consumers. Now to back up again, individual residents, sometimes that's implied by the statutory language itself. So for example, New York has a law called the New York Tenant Data Privacy Act. And what this act does is actually regulates a landlord or owner of a residential property which uses smart access technology to allow their tenants to access their living space without a key. So if you answered no up front, it might actually be a yes, depending upon the technology that you've developed in a development or a building that you've purchased. And then going to the second category, individual employees. Employment relationships are somewhat fluid. But what we actually see with a lot of these privacy laws is that they don't necessarily discuss specifics on how the relationship started. They don't necessarily even make a differentiation between an employee, an independent contractor, or an agent. They'll simply just rest on this idea that an employee has provided you with data and you as the employer now have a statutorily created obligation to that individual class. I think a good example of this is another New York law. There's actually a law specific to employee information that is provided or even exchanged not with the employer during that employment relationship. It doesn't have a fancy name. This law is called Section 52C2, but it's statewide. So you need to know what that law is if you're in New York and you're an employer. And basically what it says is that an employee has a privacy right in their telephone conversations, their emails, text messages, basically anything that relates to their private lives that is exchanged or that they happen to handle during, let's say, the term of their workday. That is something that you as an employer have to avoid monitoring without at least informing that employee that you're doing so. And you also have to be aware that the employee has to be notified that that's happening. And we'll get into notification practices a little bit later. Now, the last category, individual consumers, I say it to last because this is almost the worst of all worlds. Many of these statutes will have consumer in the title. They'll even have consumer in the legislative purchase. They'll have consumer in multiple places. But then when you start to dig through the actual language, it turns out that other categories of individuals are implicated. I think a good example of this is California's CCPA. So under that definition, which comes from another section of California's tax code, their definition and their approach to who a consumer is under the California Consumer Privacy Act basically means a natural person who is a California resident. So you can see consumer in other areas of that statute, but when you're just looking at that definition on itself, it's actually pretty expansive. It expands to all those other categories that I just mentioned. And then when we're going to this next point, this is the poll results make me want to spend a little bit more time on this one. But when we're talking about the nature of the data, I think that is where we normally see a breakdown. So honestly, we understand the idea of personal data. We understand the idea of personal information. The way is addressed in these privacy laws, it's personal information that can be tied to an individual's behavior, actions, purchasing history. If you think about it, the first time you walked into a library, probably as a kid, signed up for a library card, every single time you borrowed a book from that library, there was a record of that transaction. They had a record of when it came out, and they had a record of when you're supposed to return it. That record is now protected under many states, including Missouri, as well as New York and California. That record is protected from unauthorized disclosure. So a library record, very personal to you, and that is the type of personally tied information that most of these privacy laws are targeting. And then when we're talking about the idea of how this data can be protected or your risk mitigated, when we're looking at anonymous data, that differs from this personal data aspect because with anonymous data, there is no identifiable characteristic related to it. So that would be like going out into the street with a survey and you're asking people, will they purchase ice cream today? And the only responses are yes or no. Without more there, it's not tied to any individual. That data set may be useful for a stated business purpose, but it doesn't go much beyond that. And the last category, pseudonymous data, this one is very interesting because that is a blend of both. It's basically addressing the collection of personally identifiable information, but you're doing something with that data set to remove the personally identifiable portion. So in this case, it might be going into your database and even though you might have asked for someone's name or their address when they enrolled in a system or signed up, you might on the back end remove all those indicators. So what you might have instead is just the results divorced entirely from anything that can be used to identify the individual. And when we're talking about this biometric type data, this is very close to my heart. I threw out that acronym earlier in the presentation, BIPA. The technical name of that statute is the Biometric Information Privacy Act. Passed in Illinois in 2008. It's been on the books for quite some time now, but up until around 4 or 5 years ago, we didn't see much litigation related to it. And at this point, we probably have seen more than 800 class actions targeting employers for the use of biometrics. So when we're looking at biometrics, I think we have a general understanding of what those relate to. Fingerprints, iris scans, even handprints. But what's really interesting is that this kind of breaks down when you're talking about how these statutes, how the legislators approach defining that term. And I think there's a big difference between states such as Texas, which just uses a very understandable approach. Under Texas law, their Texas biometric privacy law just says a biometric identifier is a retina or iris scan, fingerprint, voice print, or a record of hand or face geometry. Washington's privacy law follows suit. But then when we get to BIPA, and as well as some New York laws, that is where we get more complicated. So under BIPA's scheme, there are two different definitions. There's a commonly understood term, which is embodied in the term biometric identifiers, those retina, iris scans, fingerprints, and whatnot. But then they add another term, biometric information. And this is where a lot of the danger lies, because under that biometric information definition, any information, regardless of capture method, conversion method, storage, or sharing or dissemination method, based on an individual's biometric identifier that can be used to identify an individual, counts as biometric identifiers. So technically, based on this definition, it could apply to behavioral quirks. If you have behavioral AI as part of your system, it might fall under the definition that BIPA uses. And then New York statutes follow BIPA's approach, where they expand that term of the commonly understood approach to what biometrics are to include behavioral quirks. They use the term gait, so it's clear that there's some sort of audio-visual monitoring going on, and that's being stored somewhere. And New York doesn't just do that in one statute, they actually do it in 3. So they do it in the New York Data Privacy Act, the Tenant Data Privacy Act, which I mentioned earlier, and the New York Biometric Privacy Ordinance. And when we're talking about New York's laws, just to be clear, the New York Data Privacy Act, that has not been enacted yet. The only New York law that's specific to biometrics that's been enacted is the Biometric Privacy Ordinance, which is in New York City. But that Tenant Data Privacy Act has been enacted. So it's just one example of how you might think that one law is applicable, and then it's not quite on the books yet, but there are other laws filling in that void that you might still be burdened with. And then finally, NCDs are going to fall under a very expansive approach to what a controller is. And by controller, all these statutes, they generally use different terms. These terms are generally applied very broadly to apply to any form of entity, including individuals, corporations, LLCs, data brokers, and those entities will be responsible to not only retain that data, but also secure that data using certain mechanisms. So, depending upon what your state requires, you might have very onerous retention requirements.
So thanks, Drew. And to that, I would add, when we're talking about the state laws, is that oftentimes you'll get states that enact new requirements. And we talked a fair amount about the California law, CCPA, and there was recently a law along similar lines enacted in Utah that is often being described as CCPA light or CCPA very light. That doesn't really have much in the way of substantive requirements to go beyond CCPA, but what these additional state laws do provide is a mechanism by which the AG can enforce them. So whereas now you don't necessarily have to do something different because of the Utah law, but it does create another way that you can be sued if you violate the substantive requirements. So you don't have to do anything else, but it does increase your litigation risk potentially. And I would also note that next month we're going to have a webinar with the Cybersecurity group here specific to privacy and security issues here in Illinois, including under BIPA. And I think this is going to be of interest to people all across the country because BIPA is having a nationwide impact. Our colleague, John Cullerton, who was president of the Illinois Senate, is going to join us to give some background on what was the intention of BIPA when it was enacted and how that may differ from the current state of the law, as we've seen in litigation. And then if I quickly note, we do have a question from someone here in Chicago about if an employer provides an iPhone and then that iPhone collects facial aspect information, is the employer collecting information? And I think I'll give the classic lawyer answer that it depends. But I think as a practical matter, what we're usually seeing with apps, especially apps that are on the iPhone, is that the app makers are piggybacking on Apple's collection themselves. So Apple is already collecting facial recognition or thumbprint or fingerprint or something like that. And so the app can use biometrics without ever actually collecting it. The phone collects it, and so the information resides on the phone, and then the app just receives a thumbs up or thumbs down as to whether or not it can verify the identity of the individual. So usually, even if you make an app, you're not actually getting the biometric information, although it could be that you are. I mean, you can certainly set it up so that you are. We just got a new question about controllers. Co-controllers, yes, certainly. I mean, I think here in the U.S. we often talk about it in terms of who owns the information. Controller is just who really directs how the information is used. And so you can have co-owners of information, you can have co-controllers of information. But you do have to look at how it's set up under each statute, because for the most part, most of the obligations are going to go on who is the controller of that personal information, and the lion's share of the liability, litigation liability risk is going to go on the controller as well. And so with that, let's move on to point 3. Luke.
Thank you, Jim. Okay, so I guess on the overall theme of what can you do as an organization to try to limit the odds of liability, or if you do get dinged, at least mitigate the scope of what you might be on the hook for. So the next thing is understanding where your data is processed or stored. So the first question I ask is, what is processing? What does it actually mean? And it really is asking yourself what you're doing with the data that you're collecting, either that you're collecting yourself or that you're receiving from other organizations, and then processing or doing something and sending it back. And obviously this question is going to vary very widely based upon your business, but here are a few questions to ask. As a baseline matter, are you transferring personal information to third parties? And if so, what are they doing with it? I think you really need to understand the flow of personal information, not just within your own organization, but to third parties, to really be able to assess where some of the weak points and weak spots might be. Are you transferring the data abroad? Are you transferring to any jurisdiction abroad where other laws might apply? And if you're transferring to Europe, you're dealing with obviously the GDPR. Are you storing the data in any environment that's susceptible to, or that's particularly susceptible to risk? Where are you storing it in the first place? Is it all on an internal server? Are you using cloud storage? There have been quite a few lawsuits in the last couple of years relating to data breaches of third-party servers, of third-party cloud storage servers that were inadvertently left either open to the public or that were actually intentionally infiltrated, and information was leaked, and a lawsuit resulted. If you are using third parties, or if you are transferring personal information between your organization and vendors, the next question to ask is, well, how does that data travel? And this is something that Drew touched on before, and I think is going to be a running theme. Number one, if you're transferring data, is there a way to limit what you're transferring to minimize your risk? Does the vendor actually need all of the data that you're transferring over? Does the business partner who's sending you data actually need to send to you everything that you're receiving? If so, is that information encrypted? That's obviously, I understand most folks on this call are probably not IT professionals, they're attorneys, but getting an idea of what form the information takes when it's being transferred to or from you is really, really important in trying to get an overall idea of the entity's liability for a potential breach. If the information is encrypted, is it also anonymized? Is there a way to anonymize it in a way that doesn't include certain information that might lead to higher risk of potential litigation? And it does that in two potential. If the information is anonymized, or if it's scrubbed to the bare minimum, you're protecting yourself in at least two ways. Number one, standing is a critical issue in data breach litigation. And standing is based on, and state requirements vary a little bit, but the federal requirement is actual injury. If the data that's being breached, or if the data that's leaked is as bare bones as possible, for example, names, then there's a much less likelihood that a potential plaintiff is going to be able to show actual injury for something like a name being released, as opposed to something like credit card information, bank account information resulting in identity theft. You're getting much closer to the type of harm that a court will actually recognize to allow a lawsuit to proceed. And then the other way is that statutes like the CCPA and CPRA, for example, specifically limit the type of information whose loss might lead to a private litigation. So not all data, not all personal information as defined by the CCPA and CPRA is information that, if lost, will lead or will sustain a private cause of action. That information is separately defined and includes more sensitive information, including the type of account information, bank account information that I just spoke. So again, it really is critical to understand not just what you're collecting and to whom it applies, but where you're sending it, in what form, and how it's coming back to you. So, Drew?
Oh, actually, just for a moment there, Luke. One point I would add is that a new trend of privacy laws we're seeing increasingly, and I think is potentially troubling, are data localization requirements. Requirements that if you collect certain personal information that is sensitive, it has to be processed within national borders and can't leave. And where we're seeing that most prevalently so far is in China, Russia, honestly not countries that are often considered at the vanguard of privacy, but this is something that they have cared quite a bit about. And so, and when you're thinking about potential litigation down the line, potential enforcement actions, that's something to keep in mind as well, that there are these new requirements that are being enacted out there. So then, the next thing, next of our points is to understand how your data is being used. And so I'd say the easiest way to get in trouble on privacy of anything is to not do what you say you do or do what you say you don't do. And I've seen many examples of times where someone at a company knows that the company needs to have a privacy policy and thinks, oh, we had a great one at my prior firm. I'll use that one. And so then they change the name in the privacy policy and post it up for the new company. That's a great way to get in trouble. Make sure you've tailored your privacy policy to your company and that you review it regularly, particularly if the nature of the business may have changed. If you had some new acquisition or you have some new business line that came in, make sure the privacy policy reflects that. Also watch for grand statements in the privacy policy, especially relating to security. We have best in industry security. We have cutting edge security. Those are the kind of statements that can come back to haunt you in litigation. So watch for those kind of things and make sure you're not overstating something like that. If you're obtaining consent from consumers for the use of their information in certain ways or sharing of that information, be mindful of the scope of the consent. What have they consented to and not consented to as part of that? And so make sure you stay within that. And then also take care about having the consent be freely given. Did the consumers receive something in exchange for getting their consent? Could someone argue that consumers were in some way tricked into giving their consent? There's been a recent focus by legislators and regulators on the concept of dark patterns. You see it in privacy laws in California and Colorado. It's been a focus of the FTC lately. The whole idea is are consumers being tricked into providing their information or providing their consent for certain uses of information? As we move forward, I think that's going to be a significant area of litigation and enforcement actions. And so when you look at what your statements are, have that in mind. Think about that. And it's important to know also where in the organization does particular data reside and how does it flow through the organization. It's not a direct source of litigation that you have to have this, but it is important in other ways. To know if your privacy policy is accurate, you kind of need to know where the information is, who's using it, how it's being shared. And as well as in addressing consumer requests. There are, under certain privacy laws, there's a right to request information about what information the company may have about me. And so you can request that, or you can request deletion. Well, you have to know where the data is in order to comply with that, because those things are something where you could be sued down the line for not complying with. So make sure that you put yourself in a position of being able to comply with them if that comes up. And then there's this concept now lately of privacy by design as a way to address some of these risks. So to have privacy professionals or people with at least privacy on their plate to be involved in the process when you're developing new products or services, and to be mindful of, are we really only collecting the data that we need here, or are we collecting more? What are the parameters of our privacy policy that we need to be mindful of when we're designing this thing? Does it need to be changed? So all of those are important things to understand about your data. And I'll pass it along to Drew. Oh, sorry. We've got our first secret word here. First secret word today is car. So among these three choices, if you could click on car from the list, and so that you get your CLEs today, go ahead and click on that. I'll give you a few moments to do it. So please click on car. You can see we're getting up there. Hopefully we can get everybody to click on car. easiest question of the day. Give you just a few more seconds here. Please go ahead and click on car. Okay, ready? Okay, we're gonna move on then. Okay, so Drew, collection points.
All right. This is building on what Jim was just talking about. The common feature behind privacy laws, especially on the state side, is really making sure that consent and whatever notice is provided to consumers who obtain that consent is sufficient to allow the consumers or individuals to have enough information to really understand what's going on. And I call this a combination of W's and H's questions. You should provide enough information that that individual should know what is being collected, who that data is being sent to, how long that data is being maintained, and whether that data is going to be sold, leased, or otherwise transferred for profit. So, we're basically, that can change based on the changing business needs, changing sales, tactics or goals. It could also change depending upon the context of the relationship. So if you're asking an employee to provide biometrics as part of your payroll processing system, do a time clock that has biometrically enabled features, a number of these statutes do require you to tie that to the term of their employment, or at least inform them that, why you're collecting it and how that's related to their employment situation. I think the New York Privacy Act, which is not enacted yet, still going through the New York legislature, I think they have a really nice definition that ties up what we're talking about here. That statute will define consent as the clear affirmative act signifying a freely given, informed, and unambiguous indication of a consumer's agreement to the processing of that data. And New York PA, NYPA as I call it, is going to be more interesting in that when you're giving this notice and obtaining this consent, that notice has to be specific to what you're actually doing. You can't combine it with another notice. It has to be really focused on the actual activity that you're engaging with. And I think that the common approach would be to combine as many of these things as possible into one release. But under New York law, they are taking a different direction. They think that in order for informed consent to actually be given, you have to address this specifically in a separate type of conversation in a separate instance. I'll get into this later, but they also impose additional requirements that are going to provide the consumer with enough information, and some of this information reflects legitimate policy concerns. I think under the NYPA, what they want to do is have it specifically legible for anybody to read, as long as that person is able to read at an 8th grade level, as long as it's in a clear, conspicuous place and they can see it, questions about it. So that reflects a bunch of policy concerns that they have. And when we're talking about notice at collection, that seems very obvious. So both the CCPA and BIPA have this among their requirements. But what's really interesting, and this kind of combines with the next bullet points, some of the notice requirements are fairly spelled out, and some of them are actually quite onerous, whereas others are a little bit more flexible and ambiguous. So under the CCPA, not only must you provide consumers with that information that I mentioned before, but you also have to give them the opportunity to opt out or opt in, depending on their age, of any sort of sales or transmission activity that you're dealing with their data. And under BIPA, notice at collection, that means before you collect their biometrics, that is when you have to actually post that notice somewhere where they can read it. And that notice can't just say that you're collecting biometrics. It has to specifically lay out retention requirements, basically how long you're retaining it for, what you're collecting, why you're collecting it, and they actually have a timeline incorporated into this notice as well. You basically have to tell them the length of time that you're going to hold those biometrics, because 2 time frames apply. The first time frame, and it should be your permission expires, just to be clear, at the earlier of these 2 time requirements. But the first one is as soon as the stated purpose for your collection has expired, or 3 years after that individual's contact with your entity has expired. And when you think about those 2 specifications, those are imposing additional record keeping and monitoring requirements that are not quite obvious when you're just reading through the stated purpose of that statute. And when we're talking about specifics as to what type of notice that you have to be prepared for, under the CCPA, they want 6 points of consumer information to be provided in an easy understand language. So, and this is similar to, I think, the direction NYPA is going, but they want you to tell them the categories of personal data that are being collected. They want you to provide the identity of third parties that you're exchanging this data with. They want you to, besides those opt-in and opt-out, you basically have to get this, the permission from the consumer to transmit that data, even if it's not being sold. So under the CCPA, you basically have to go through a laundry list, and they're going to add 2 more notice requirements as well. And these notice requirements, when the CPRA, when that goes into force on January 1st, 2023, that's going to allow consumers to contact you to delete that data or even ask to correct some of that data. And I think what's most important is that it's going to impose a private right of action and expand a lot of the CCPA's current provisions to the employer relationship. So this is another example of how, even though it's supposed to be a consumer-oriented statute, when it's targeting consumers, it's actually taking a very expansive, broad view. And you might start to see employers bringing lawsuits against employees bringing lawsuits against their employers for violating CCPA's very stringent requirements. And then going to the next point, when we're talking about notice, one thing to be wary of is don't just provide the notice without understanding why you're collecting that data. And the best way for me to back up and explain it is, I think we're used to the idea of providing a release or a notice of consent form before we collect data as part of a consumer transaction. Under some of these statutes, consumer transactions, the sales of that data are not allowed. The Biometric Information Privacy Act doesn't allow it, even though Texas's own Biometric Privacy Act does. But Texas does require you to get consent from that consumer before that sales activity occurs. So the short summary of that is, before you engage in sales activity, check your state statute and make sure that somewhere hidden away in their provisions is not expressly barring any sort of commercial activity or transmitting or use of that data and anything that could be considered sales activity, because certain statutes just completely bar that activity entirely. And you don't want to be caught with thinking that by providing this notice and informing a consumer that the data can be collected and transmitted, that you're covered. You might not be, and it's so state-specific that you're just going to have to pull up the statute itself and confirm whether or not that's a problem for you. And I think just on that last point, New York takes a very interesting approach to this. There's 3 different laws. I mentioned the ordinance before. So the ordinance in New York City does not allow the sales or transmission of biometrics. But the Tenant Data Privacy Act that relates to smart access buildings in New York, they do. You just need to collect informed consent before that sales activity occurs. And then the New York Privacy Act, as drafted, it only really restricts the transmission of that data between data brokers. So Jim had mentioned the Attorney General's role in this scheme before, and this is where the Attorney General really comes into play, because these data brokers are required to register as data brokers, not only in New York's law to come, but also under the CCPA. And what data brokers have to do is basically pay a registration fee and basically identify themselves for the Attorney General, which on the law, in the grand scheme of things, will make it easier for the Attorney General or individual citizens to bring suits based upon what they perceive of or alleged violations.
Okay, sure. And this last point on GLBA, this is really just to contrast what we're talking about, the notice and consent here. Is GLBA, it doesn't require notice at collection. It requires notice to a customer at the creation of a customer relationship, or to a consumer before you would engage in sharing that would require an opt-out. So that's an example of something that's a little different than the notice at the collection point, to differentiate it from some of those state laws. And then there's a question out there about, with regard to privacy notice, how do you have a privacy notice that's compliant, but then also is not noisy for the user experience? And I would say it's a constant tension. I think one of the ways you can address it is getting multiple parties involved in the drafting process. Ultimately, this is a notice to comply with legal and regulatory requirements, and so it has to ultimately do that. But bring in marketing people, bring in other people who may, because I'll admit we as lawyers can be a little bit wordy, shocking as that may seem, as well as the fact that the notices themselves can get to be cumulative. And so you keep adding on and adding on each year, and so suddenly then you look at the notice and you realize it's 14 or 15 pages long. Every so often it needs a hedge trimmer taken to it, and see if you can replace an entire paragraph with a sentence and essentially say the same thing. So I think you need to constantly take a look at it, but also be mindful of where you might be able to pare it back and who might be able to give input on doing that. So the next thing here, we have a poll question. Do you know the privacy and security obligations on your organization that you have in your contracts? Yes, we have a standardized cataloging of all of our privacy and security obligations across the enterprise. Or yes, we generally keep track of where agreements may differ from normal privacy and security terms, or sort of. We try and keep these obligations consistent, but we know there's some variations out there somewhere. And then the last one is, you mean we have to actually do all those things in those long contracts? So if you could briefly give a vote, and we'll check the results, and then we'll move on to the next thing. I'll note right now we're probably going to go a little over the bottom of the hour, but we will finish up here. So the results, sort of. Yeah, I think this is an honest response because I think it's hard to keep track of all this stuff, and quite oftentimes the bargaining power is that you can't put in the terms that you'd like to. You can't keep them consistent. Sometimes in dealing with very large or business partners may have a lot of power over you. Luke, so let's talk more about contracts.
Yeah, thank you, Jim. Well, I think the last poll was very telling. I think something over 42% responded that you know your obligations generally, but that they vary. Since this is a webinar on litigation risk, I really can't stress enough the importance of understanding your contractual obligations, because your compliance with statutory and regulatory requirements is really just part of the story. The other and often more significant part of the story is complying with what you've agreed to do in your own contractual obligations. You may have signed up for all sorts of obligations that you're not even aware of, and this can come in several different forms. So it can come in the form of reps and warranties. So if you're a service provider, if you're a contractor to any organization from whom you're receiving personal information, it's almost a certainty that you will have signed some agreement relating to how you will safeguard the data that you're receiving. And in those agreements, you will have signed, you will have made various representations and warranties regarding how you will treat that data. You will have signed warranties regarding your own security practices. You will have likely signed reps and warranties regarding your own compliance with various privacy laws that might apply. And you might even have signed representation and warranty about insurance coverage for cyber incidents in case something were to occur. And to avoid litigation, which again is really what this webinar is about, you really need to understand at every level of the organization what you've agreed to do, so that you're not surprised, so that if something were to happen, you don't look at a contract after the fact and say, well, goodness, I didn't realize that we had committed to do this, and as Jim mentioned earlier, we just didn't. Because if that happens, there are obviously a number of consequences, the biggest being indemnification. And the indemnification can be based on a breach of reps and warranties, or in some contracts, it can be an indemnification based on your commitment to specific to indemnifying over security incidents. And again, that's something that really you don't want to be surprised with after the fact. And that's something that you really need to take into consideration, because there are a number of decisions out there that have enforced limitations of liability, have very strictly enforced certain limitations of liability as to these particular provisions. So you not only need to understand what's in your current contracts, and to the extent you can, standardize it so that no matter which customer experiences an issue, or which customer data might experience an issue, you know it's coming, but you can get ahead of it by limiting your liability, and again, subject to your bargaining power in particular types of relationships, but you can get ahead of that type of liability so that you're not surprised if it comes. And then the flip side of the coin. If you are the entity that is giving personal information to third parties for processing, for storage, analysis, for whatever purpose, you need to understand what those entities are, and you need to understand what they're doing with the information and their own security practices with respect to how they are safeguarding the information that you provide. And again, it's simply the flip side of the coin in the case that the data is breached and you're the entity that collected it, and you're seeking to ensure that the folks to whom you're giving it are treating it properly. So you're the entity now that is going to want the robust reps and warranties relating to data security. You're the entity that's going to want as much indemnification as possible relating to data incidents. And you're also going to want to know, in general terms, and in some cases in specific terms, and there are statutes, including notably the GLBA, that specifically mandates vendor compliance, you're going to want to know what the programs are that your vendors are implementing to secure that data. And there are a number of commercial frameworks available. There's a number of certifications, including SOC 2, and there's some commercial frameworks available that allow you to assess that in a structured format, such that if something were to happen, you're at least protected that way. And those include NIST and ISO. And the last thing I'll say is that some of these protections that you get by ensuring that your vendors are treating the data properly are statutory. For example, the CPRA, the CCPA, and the CPRA has a specific provision that says that if you're a business that provides personal information to contractors and you do so pursuant to a contract that specifically limits what that vendor may do with the data, and you don't have a reason to know that the contractor is doing something different with the data than the contract provided, then your liability is limited in that way. So there are specific statutory even protections if you take these suggestions to heart.
Okay. Thanks, Luke. So security breaches. I'm going to move quickly through here. So litigation based on security breaches, you can divide it into sort of two types. I mean, there have been some actions by state AGs, and these fall into three basic categories. So an entity failed to provide notices to state residents when they should have. Notice was provided to state residents, but it was provided later than it should have been, or that the entity that had the incident failed to maintain reasonable security. This has mostly been in Massachusetts, but we've seen it under some other states as well. For consumer actions, many state breach notice laws don't expressly permit a private action. Where actions have been brought, they generally had not advanced, usually because there's a failure by the plaintiffs to show actual damages. I think we've seen slow but incremental advances by plaintiffs, though cases are not getting to trial. That is changing, I think, in large part because of CCPA, and where California sought to make breach actions easier to bring. So consumer can bring an action under CCPA where there's been a security breach, where the entity failed to maintain reasonable security. Consumer then has to notify the business, and the business fails to cure the security shortcoming within 30 days and provide a written statement about that cure to the consumer. In those cases, then, it allows the consumer to bring an action for the greater of actual damages or statutory damages of $100 to $750 per consumer per incident. And so that is significantly increasing litigation in this space. And I would also note that the types of attacks we've seen lately, there's been, obviously in the last few years, a huge amount of ransomware. And a ransomware attack is not necessarily a security breach because there's not necessarily data that's accessed or exfiltrated from the system. But there is a common tactic that's being done to exact full leverage over the victim to exfiltrate a cache of data prior to encrypting everything on the system, so that there's an additional way to make someone pay the ransom. If you don't pay to get the data decrypted, you'll pay at least to get the data back or get that data destroyed that we took out before we encrypted everything. So be mindful of that, is that this attack vector, the way that ransomware is being done, could lead to litigation under a statute like CCPA. And so with that, we're going to move on to the next secret word for CLA purposes. The second secret word is SKY. So please select SKY from the list below here. Do it quickly, and we'll move on to these final few slides and wrap up today. So select SKY from the list on your screen. I'll give you just a few seconds to do that. We've got two more of the 10 points that we're gonna hit on here. As I said, we might go a little bit over, but we'll try not to go too much over. So please click on SKY on the list, and okay, click SKY. We're gonna move on. Here we go. So let's Luke, applicable statutes.
Sure. Thank you, Jim. So the last, I guess second to last of the 10 points, but the last of the 10 points that really addresses what you can do to try to lessen or minimize your risk is understand the applicable statutes and the developing law. And this is probably the most challenging because the law is very quickly developing, and it's certainly difficult to keep track. And that's made even more difficult by a couple things. Number one, they're overlapping requirements. That there is no, as of today, there's no federal privacy framework. There are industry-specific privacy frameworks, as Jim mentioned, and then there are state laws that provide various protections regarding various types of information. So far, there are only 4 states that have what we call comprehensive privacy legislation that applies across the board. They're California, Colorado, Utah, and Virginia. There are 14 others in some form of pending, and many more introduced and will likely be introduced. So keeping track of those, especially where they might be overlapping, truly is difficult. But you have to, because if you're a financial institution that's doing business in California, for example, you're going to have obligations imposed on you by Gramm-Leach-Bliley, and then you're going to also have information that you're going to have as an institution that's going to be covered by the CCPA. And understanding what types of information and which laws apply is really important to making sure that that you don't run off the track. And on a very similar note, depending on what the type of information is and which laws apply, you also need to understand where the sources of the liability might be. As the slide says, you're dealing with private rights of action, and the private rights of action can be under common law. Certainly, data breach actions are primarily, and even today are primarily brought under common negligence theories that don't require necessarily a specific private right of action, but that are still viable if mostly if they clear the standing requirement, but still are a source. State actions are also possible by state AGs and the FTC, and really where that's useful to know is if you know the particular data that you're storing is subject to a particular state's law and subject to a particular state AG's jurisdiction, you can at least figure out what that AG may be focused on. For example, the California AG a couple months ago said publicly that he was going to be focused on customer incentive and loyalty programs under the CCPA. That's helpful to know. If you happen to be a company that has those types of programs, it's certainly useful for you to know that the California AG publicly expressed interest. There is an expanding, but still relatively small, but very rapidly expanding body of case law on such issues as what are reasonable requirements. That's very helpful to keep track of, again, in an industry-specific format, especially to better understand how a court might view the types of practices that you've employed to protect information. And same thing on the standard of care, which is really the same thing. You really need to understand, based on where courts are going, where opinions are going, what courts are going to find reasonable or not. And then the final point on this slide is certainly in the litigation context, privilege is absolutely critical, both in minimizing your liability if you do get sued, and then obviously during the course of litigation and litigating to the best outcome possible. Issues of privilege in data breach class actions are really at the forefront right now. There were a number of opinions in the last few years where courts have required the production of data breach reports and data breach analyses, finding that those types of that certain reports were not entitled to work product privilege because they were either prepared in the ordinary course of business or weren't prepared specifically in anticipation of litigation. Again, really something critical to kind of keep an eye on, because if you do get breached, how you decide to conduct yourself in terms of retaining a company to analyze the breach, retaining a law firm, all that needs to be done with an eye towards maintaining the privilege to, again, reduce the overall liability should a suit occur.
Okay, thanks, Luke.
Jim?
So here's our final polling question. Our final polling question of today. So we've got, do you have a firm grasp of what is covered and not covered under your cyber insurance policy? Yes, we've reviewed our policy and clarified what is covered and the resources we have under the policy, or we know the basics of the coverage, but coverage is not clear, or at least we've not submitted a claim for it yet, or coverage has become too expensive and we are just going to self-insure now. So if you please give me your choice here, and we'll quickly go over the results, and I'll do the last of our 10 points, which obviously relates to insurance. So give me your thoughts here. We're up to just about 50%. Let's get a few more. Okay, let's check results. And the winner is we know the basis of coverage, but some coverage is not clear. This is where I would have probably thought. Honestly, I'm surprised that a third of people feel that they have a good grasp on it, because this is a tough area. And I'll note just here, 10 years ago, cyber policies were uncommon and typically very expensive to have. As the insurers became better at pricing risk, the cost of the policies dropped significantly, and we saw many companies that acquired cyber policies. And then in the last few years, the explosion of ransomware has resulted in some very large costs to the cyber insurers. And so as a result, the prices of policies and deductibles have, again, gone up quite a bit, and the coverage amounts have gone down. This teamed with the fact that cyber policies are not nearly as standardized and familiar as in other areas of insurance. We have different terminology, different structures of the policies, and this has all led to an increase in coverage disputes relating to cyber policies. And on that point, I would note that at 1 o'clock Central, our colleagues Matt Darrow, Dave Duffy, John Atkins are going to have a webinar where we're going to delve deeper into some of these insurance coverage litigation issues, including under cyber policies. And so please go and register for that if you have not yet at this time. So with that, I'd like to thank everyone for attending today. We appreciate you attending. We hope this was helpful to you. If you have a chance, please complete and submit the survey that will appear at the conclusion of the webinar. And I'd like to thank Luke Sosnicki, Drew Moore for participating, and you for coming. And we'll see you at our next webinar. Thanks very much.